Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Several of you sent me an article on the CBC, and it's a really interesting article that talks about a really interesting case. And so the article, the headline is Sentence for Ex-Mountie Exposes Two-Tier Justice System, Manitoba Prosecutors Claim. I'm going to link the article in the description below. I'm also going to link all of the case law I talk about. So what's going on in this case? And it's the case of the Queen and Letkeman. So Mr. Letkeman was a police officer at the time, and he was pursuing a vehicle that he thought was being driven by an impaired driver. In the course of this pursuit, which was described as a low-speed pursuit, it's 30 to 40 kilometers an hour, but it's in snowy terrain, and so people, this is possibly fast for the terrain here, but the officer attempts a pit maneuver in order to disable the other vehicle. Now, pit maneuver is a sort of controlled precision strike of one vehicle against another in a precise way in order to try to disable it. The problem is that Mr. Letkeman was not trained to do pit maneuvers and was not authorized to do pit maneuvers. Ultimately, however, this is unsuccessful. It doesn't stop this vehicle, and all it does is cause damage to the vehicles. He then continues pursuit, and he radios in and gets permission to continue this pursuit. He's authorized to continue the pursuit by his superiors. Critically, however, he doesn't tell his superiors at this point that he has attempted this pit maneuver or that there's been a collision. So when they give this authorization, they're in the dark as to what's really happening here. As this pursuit continues, he then eventually makes the decision to ram this vehicle, and he T-bones it into the passenger side at quite a high rate of speed. This ends up causing very serious injuries to the passenger. It breaks her pelvis, it injures her neck, serious injuries here. And, this was an intentional decision. It should also be noted the passengers apparently this entire time were, yelling to the driver that he should stop, stop. And the driver wasn't listening. We ultimately don't know what was going through the driver's mind at this point, because after this collision, the officer, Mr. Letkeman, gets out of his vehicle and ends up shooting the driver. He fires 11 shots, and the driver is killed. Now, the decision of the court at the trial level was that those shots were justified. So the sentencing of Officer Letkeman was not based on those shootings. It was solely based on the driving transaction. And ultimately, the sentence that is awarded is a matter of contention, because it ends up going to the Court of Appeal later. And so we see the conclusion here in terms of the sentencing. And so the judge notes, I end where I started. As devastating as it was, the shooting and its consequences must not creep into the sentencing. And that's quite proper. If Mr. Letkeman was acquitted on the shooting, then it shouldn't be a reason to ramp up his sentence. However, they say, for the charge of criminal negligence causing bodily harm to Ms. Flett, I sentence Constable Letkeman to a 3-year period of probation with the statutory conditions set out in the code, except that I decline to impose the non-communication provision given the exceptional nature of this case and the time that has passed since the offense arose. Further, I have no concerns for the safety of Ms. Flett or other witnesses from Constable Letkeman. So normally, in a case like this, you'd ban the accused from, or the offender at this point, because this is a sentencing, from having communication with the witnesses or the victims here. But he says this is kind of a weird case. It's not necessary, and fair enough. I also order that he perform 240 hours of community service work within 18 months, but not at his church. Now, this is fairly common where they say, where somebody is already in a position where they're volunteering on a regular basis, you don't want the community service hours to just be what you were doing anyway. It's supposed to be punishment, right? So they'll say you got to do some additional community service hours, something else. So that's why they're saying not at his church. Pay a fine of $10,000 within 3 years. Default to be calculated pursuant to sections of the criminal code. So that's if he doesn't pay, how much time does he have to do in jail? Victim fine surcharges are waived, and he's banned from driving for 12 months. And there's an additional thing here that I'm going to come back to. It's with regards to the firearm prohibition. So that I'm going to talk about a little later. Now, you might be wondering, why do we get there? Like, how do we not get a jail sentence on this kind of scenario? And essentially what they rely on is Mr. Letkeman's background, because they note that there's a bunch of aggravating features here. They say that he twice intentionally crashed into a vehicle he was pursuing against policy and any reasonable risk assessment. This was potentially lethal force, according to expert evidence I accepted. So this was heard at trial. Further, he did not tell his superior he crashed into the Jeep the first time, depriving her of vital information she would have used to instruct him to end his chase and let the Jeep go. And I mean, it's kind of open to the court to conclude that that might be why he didn't tell his superior, right? Because the superior might have said, whoa, stop pursuit. We'll get a helicopter in, we'll get, other cars to sort of box him in and so forth, but you got to stop. Didn't do that. They said Constable Letkeman was not trained or qualified in pit maneuvers and had no ability to properly execute one. Almost all of the necessary preconditions required before attempting this were lacking here. It was a rash, undisciplined move to attempt this flawed procedure, and that's not the one that causes the injury. Constable Letkeman was aware the Jeep was occupied by not only the driver, but 4 passengers, all of whom were, of course, at risk in this circumstance. The second crash was more significant in that he T-boned the Jeep on the passenger side. Serious injuries resulted from the crash, and Constable Letkeman breached the public's trust that he execute his duties consistent with training, policy, and good sense. And they note that the impact on Ms. Flett was significant, and she was wholly blameless for what happened. She will suffer the injuries from the crash for her life, physically, emotionally, and financially. Understandably, she is angry. I note that much of her ongoing disability is related to the shooting. So she's pissed at Mr. Letkeman, and can you blame her, right? Now, there's various other things that they note here. They say the consequences to Constable Letkeman are profound. He now has serious psychological issues, including PTSD, anxiety, and depression, and he's lost his employment and his career, and that's, from what I understand, because he's now on medical leave, although the conviction may have sealed that as well. He's a person who does a lot of volunteer work, apparently. He is somebody who was held up as a sort of a paragon of his community before this. He apparently does a lot of, or did, I don't know what was going on here, but he had 120 or over 120 letters of support from friends, neighbors, fellow congregants, and RCMP colleagues attesting to his decency, caring, and strong character, rife with examples of mentoring and concern for teens and young adults, volunteering at hospitals, such as on crisis support team, helping neighbors and friends, including opening his home to those in need, and active involvement in his church. It is an understatement to say he's held in high esteem and has led an exemplary life that many describe as selfless. Fellow officers are surprised by what happened. They considered him a hardworking, dedicated officer who displayed calm and respect to everyone, including those on the other side of the law. So this is apparently uncharacteristic for him, and so that is those are positive circumstances that will push a sentence downwards. Now, as noted, he doesn't get any jail time as a result of this at the trial decision. They imposed 3 years of probation, $10,000 fine, and a 240-hour community service aspect. Now, on appeal, the Crown took this up to the Court of Appeal in Manitoba, and they said, listen, we don't think this is a suitable sentence. We think he got off way too light. And the Manitoba Court of Appeal agrees. They say, listen, this guy is a police officer. The court overemphasized his individual circumstances and underemphasized the principles of general deterrence. And general deterrence, what that means is, so there's 2 kinds of deterrence. When sentencing somebody, you want to deter both the specific person by sending them a message of, listen, you did the thing, look how much the punishment sucked, so maybe you're not going to do the thing again. You are specifically deterred because the punishment sucked for you personally. But there's also general deterrence, which is that other people should be able to see what happened to you and come to that conclusion themselves. They see, oh, look, that guy did the thing. He got punished. It really sucked for him. So maybe I won't do that thing. And, that is considered particularly important when we're talking about police officers often because, you want to deter specifically other police officers. Now, so the court does accept that was an error in principle. And they say, so I'll just look, this is from the Court of Appeal decision. They say, despite the judge's comments about denunciation and deterrence being paramount, he crafted what was, in my view, a largely rehabilitative sentence that focused on the circumstances of the accused. A jail sentence may have had little benefit or utility to the accused in terms of his rehabilitation or specific deterrence from committing other crimes. And fair ball here, right? This is probably not somebody who needs to be specifically deterred because he's not a police officer anymore. You don't need to correct his behavior in policing. And it's unlikely that he's going to start, pulling pit maneuvers on random cars as he drives around as a private citizen when he's eventually allowed to drive again. So they say, but it would have an important purpose in deterring other police officers from overreaching the bounds of their authority and venturing into criminal conduct, and in loudly denouncing such conduct. And they note here, moreover, after imposing the sentence, the judge commented that the community work, fine, and driving prohibition were meant to provide a measure of punishment that probation alone could not accomplish to further address general deterrence and denunciation beyond the criminal conviction and loss of career. However, a probation order cannot be imposed for purely or primarily punitive reasons. Rather, probation conditions are meant to be to primarily address rehabilitation and reintegration, which are not really at play. It follows that the sentence did not, in fact, reflect the principles of denunciation and deterrence to the extent that the judge considered appropriate. So because of those errors that are identified, the Court of Appeal says, listen, we are going to change the sentence. And so they go through a lot of analysis in terms of what they consider to be a fit sentence. And the Court of Appeal essentially comes to a different conclusion here. So ultimately what the Court of Appeal says on sentence is, however, a jail sentence is called for. A custodial sentence is required in order to address the accused misconduct, which seriously undermines the bond that should exist between the public and the police. As stated in Baxter, any behavior that undermines that bond is injurious to the public good. Moreover, regardless of the breach of trust, the accused's conduct involved a significant degree of moral blameworthiness and caused serious injury to Ms. Flett. That said, the sentence must also defer to the judge's factual findings, including that, when the accused committed the offense, he was trying, albeit misguidedly, to protect the public. As well, the sentence must consider the accused's significant mitigating personal circumstances and the collateral consequences he has already suffered. In all of the circumstances of this offense and this offender, and having regard to the case law, I conclude that a fit sentence would be 10 months imprisonment. Now, the collateral consequences here are largely that he's lost his job, right? And we'll talk about that a little later when we get to the further appeal. They say, however, as I explained, the sentence in this case will be shorter. Following the sentencing, the Crown did not move under Section 683 sub 5 of the Code for a stay pending appeal of the sentence imposed by the judge. The accused has now paid the fine in full and completed 290 hours of community service, more than the 240 hours ordered. Because the accused has already borne the punishment of payment of the fine, I would retain that part of the sentence. Now, I should note here, the accused could have equally applied for a stay pending appeal. Why might you not do that? Well, because if you are the accused and you're sitting there and you're really hoping that the appeals court doesn't sentence you to jail, it makes a whole lot of sense to sort of put as much kind of sweat equity towards the existing punishment as you can. You want to commit to that punishment because then you can say, look, I put in 290 hours. You can't give me those 290 hours back, right? So you better not re-sentence me. You better not disturb that sentence. I mean, that is potentially a tactical consideration. I don't know if that was what they were thinking, but that's certainly a potential here. And so they take into account the fine in determining and grant credit for the community service. And in the end, that takes them to one of 3 months imprisonment. So they say 10 months would have been suitable, except he's already done this stuff, so we're going to cut it down to 3 months. And so that's a really much lower sentence. Now you might be wondering, how many days in jail did this officer actually do? Because we'll get a little further there and we'll talk about stay of execution. Because they were asking, the defense was asking for a stay of execution of the custodial portion of the sentence, which means that they are asking the court to say, listen, notwithstanding the fact that you've ordered 3 months in jail, I shouldn't have to do any of it. And the court ultimately grants that. They say, that there's a number of principles that they have to consider, which include the seriousness of the offenses for which the offender was convicted, the elapsed time since the offender gained his or her freedom, and the date of the appellate court hears and decides the sentence appeal, whether any delay is attributable to one of the parties, and the impact of reincarceration on the rehabilitation of the offender. And so ultimately they say, in conclusion, I am satisfied that the sentencing objectives of denunciation and deterrence and general deterrence can be met without now incarcerating the accused. Permanently staying the incarceratory portion of his sentence would not be contrary to the interests of justice. So, how much jail time does this officer do? Not a single day. Not one. He's sentenced to 3 months, but he will not end up going into the jail sentence in order to do it. So, it's just a nominal sentence. It's not really a practical sentence in that he's not actually going to do that. Now, there's a dissent in this case, and it comes out swinging. A dissent, of course, is not the decision. It's not the winning side, but you have multiple justices at the Court of Appeal, and so sometimes one of them is outvoted, but they still want to convey what their thoughts are on what should have happened. So that's what's happening here, is this justice saying, listen, I'm not, I'm outvoted, but this is what I think ought to have happened. And dissents are important because they allow for that justice to convey their thoughts on it. And often when cases are later overturned at the Supreme Court, they might say, listen, we actually think the dissent had it right. So that's a possibility. Let's have a look at what the dissent says. So as I mentioned, they come out swinging here. They say, this appeal raises the difficult issue of a fit sentence for a police officer who uses excessive force in the course of his duties. It is an important decision, particularly in the present social context, as it directly impacts public confidence in the administration of justice. Parliament has given police officers special protections in Section 25 of the Criminal Code to use as much force as is necessary to reasonably execute their lawful duties. In this case, the accused abused that authority, and his use of force was criminal. He was convicted of criminal negligence causing bodily harm. Public confidence requires that the community know that police officers who commit crimes using excessive force will be dealt with harshly by the courts. The accused drove his police cruiser directly into the side of another vehicle, the Jeep, on 2 separate occasions, knowing that it was fully occupied. There was no reason to ram the Jeep. On both occasions, the police cruiser struck the Jeep with lethal force. On the second occasion, the Jeep was stationary. An innocent passenger, Ms. Flett, in the rear seat of the Jeep suffered serious and life-altering injuries, including a fractured pelvis and serious neck injuries. The accused escalated the use of force, knowing that he had the ability to get guidance and assistance from other officers, that any action he would take to apprehend the driver of the Jeep would place innocent civilians at risk, i.e. the passengers, and that he had adequate time to weigh the options before escalating the use of force. Significantly, the second use of force was not directed at the driver's side of the Jeep, but at the passenger side of the vehicle. The trial judge found that the accused actions were intentional, dangerous, and a marked and substantial departure from the standard expected, that he used unjustified and excessive force, that he acted recklessly and with a complete disregard for the safety of the passengers in the Jeep, and that he must have been aware of the risks he was taking. Notwithstanding those facts, the trial judge decided, when sentencing the accused, that the accused never meant to hurt anyone, and they imposed a fine, community service, and probation. And here is where I think sort of the money is. It is inconceivable that a civilian offender in similar circumstances would receive such a lenient sentence. A fine was never a fit sentence, or a component of a fit sentence, for this offense and this offender. leaving aside the fact that most offenders could not afford to pay a $10,000 fine, a significant period of incarceration was and is required. And I'm going to come back to that most offenders could not afford to pay a $10,000 fine bit, because that's actually part of the appellate arguments, or at least on the leave application. And I expect if this goes to the Supreme Court, it'll be part of their arguments in the larger context. So I'm going to skip past most of this and just note what the dissenting justice would have imposed here. And that is, after taking into account all of the applicable sentencing objectives and principles, the mitigating and aggravating circumstances described by my colleague, and the sentencing judge's inclination to show leniency, it is my view that an appropriate sentence would be 36 months incarceration, so 3 years, reduced by 6 months for the community service performed by the accused, repayment of the fine to the accused, and the setting aside of the probation order. So, hey, you paid the $10,000 fine. That's spiffy. Here's your 10 grand back, and off you pop to jail, because I think you should do 3 years, but we're going to give you 6 months credit because you did do a lot of community service, and we can't give you that back. And now there was the question of a stay of the remaining incarceration. And the dissenting justice says, the notion of a stay is also inappropriate. The accused has never been incarcerated. While it is true that the Crown could have applied for a stay of sentence pending the outcome of this appeal, the accused could have done the same thing. The accused knew within 30 days of sentencing that the Crown was appealing. He did not have to pay the fine. As this court said in the Queen and Burnett, in serious cases where denunciation and deterrence are the primary considerations, reincarceration may be necessary despite significant hardship to the accused and the risk it may pose to his rehabilitation. So, and this isn't a situation where sometimes you might want to stay a sentence where, for instance, like let's say the accused gets a 1-year sentence and they do that whole year, because it takes a while for the case to get to appeal, and they get out, they put in significant effort to rebuild their life. After that point, they get out, they get a job, they get an apartment, they put all of this effort in, and then on appeal, the appellate court says, listen, we actually think that the appropriate sentence was 18 months, not 12. So another 6 months. So you got to go back in. But then at this point, that person has put in all this work to get the job, to get the apartment, to buy new furniture, all of this stuff that's going to be lost if they go back in. And the court might say, listen, as much as we want to indicate that it's 18 months for the purpose of anyone else who might be sentenced in your situation, we actually think at this point blowing up that work that you've done in terms of rehabilitation would be, not in the public interest, so we'll give it a pass. But the dissenting justice here points out that's not the case here. This isn't somebody who is, where we're going to be ending up breaking up their sentence in a way that causes them additional harm. This is somebody who never went to jail and chose not to apply for a stay. It's not that he applied and wasn't granted one. He chose not to apply. So, isn't that also on him? So that's kind of the state of things as they stand right now, which is, Mr. Letkeman doesn't have to do any jail time, but the Crown, as I think I mentioned before, is seeking leave to appeal this. They're asking for permission. So I've got their leave to appeal documents, and we can look at some of their arguments on this one because it's really fascinating, and it may represent a major sea change in sort of prosecution approach to policing in Canada. So let's have a look at some of this here. So they note, and this is again from the Crown materials, the public is taking to the streets to demand justice and accountability. It is speaking with a voice that has never been louder than in this current social climate. The public harm caused when accountability is absent is devastating to any society, including one that is going through the societal shifts ours is now. When a police officer abuses the unique power inherent in their role, the sentence imposed must reflect the level of harm inflicted on the public confidence in the administration of justice. It must hold the offender accountable for the gravity of the breach of trust, of the social contract, and acknowledging society's increasing demands that police officers are to be held to a higher standard. The sentences imposed in this case expose serious flaws in our justice system. Police officer offenders have historically received lenient sentences which no longer reflect societal values about the inherent harm inflicted when they exploit the authority bestowed upon them. They evidence a two-tiered justice system, which treats offenders of means and good community standing differently. As demonstrated in this case, including lower courts' reviews of the precedents relied upon, sentences imposed upon offending police officers are inadequate and come nowhere close to denouncing our society's repugnance of these offenses. This court now has the opportunity to offer timely direction regarding the unique factors which must be considered when sentencing police officer offenders. The problem is a national one, if not currently an international one, which calls out for this court's attention and intervention. And I'm just going to say, like, legal writing varies dramatically in terms of quality. You end up, as a lawyer, you read lots of people's briefs and so forth. That's powerfully written. I think that is a very powerful introductory statement. And so I'm kind of impressed. Like, that is good work. So the Crown makes a number of arguments in terms of why this is a matter of national importance, why the Supreme Court should hear this. And the first thing they say is, listen, societal attitudes towards police abuses have been changing. They say Canadian society is more attuned than ever to the enormous responsibility instilled upon police officers. And they note that sentencing regimes and precedents are not stagnant. They also note, they say, existing precedents do not adequately address the wrongness of these offenses. So they go and they do some case law review to basically point to a number of cases and say, listen, police officers have not been being sentenced appropriately. And so they identify a number of cases. They say in Baxter, a 15-year veteran of the police force responded to a radio call about an individual causing a disturbance. The victim was known in the area for aggressive panhandling. Baxter used excessive and unnecessary force to detain him. The victim fell to the ground and suffered an injury to his face. Baxter was caused with assault causing bodily harm. He was granted a conditional discharge and ordered to perform 200 hours of community service work. And a major portion of their argument here is they're saying, people often often sustain serious injuries from these, and that most civilian citizens would not have had the benefit of such lenient outcomes as the police have been receiving. So they quote another case, Xeraphonitis. They say the police officer offender in Xeraphonitis pled guilty to assault causing bodily harm. While responding to a noise complaint at a bar, he encountered the photographer who had been hired to take pictures of an event there. The photographer began recording the police officers who had attended and was asked to stop. When he did not, Xeraphonitis attempted to arrest him for public intoxication. The photographer resisted, and Xeraphonitis punched him in the face. The victim suffered fractures to his nasal floor and orbital bone. The police officer offender received a suspended sentence, so probation, no jail time. In Lavallee, the police officer offender had detained the victim in the drunk tank. For unexplained reasons, Lavallee twice punched the victim in the face, resulting in a bleeding mouth and gums and a missing tooth. On appeal, the Alberta Court of Appeal upheld the 60-day intermittent, so weekends. It's a 60-day sentence, but you don't do it all at once. You serve it in portions, which is typically weekends to allow you to work during the week, and 2 years of probation, which had been imposed by the sentencing judge. And in most cases involving civilian offenders charged with criminal negligence causing bodily harm, the sentence imposed is a significant period of jail. This is to be expected given the high degree of moral blameworthiness required to establish the offense. Doring is a rare reported decision involving a police officer offender convicted of criminal negligence causing death and also failing to provide necessities of life or necessaries. The victim, a young Indigenous woman in Doring's custody, was in medical distress. Doring failed to get her the life-saving medical assistance she required and lied to other officers about her condition. In passing sentence, I'll skip over that here a little bit. The Crown recommended a 2-year sentence. Only a 12-month custodial sentence was imposed, in large part due to the sorts of mitigating factors described above. So essentially they're saying, look at these cases. Police officers are not being held to a higher standard. They're being held to a lower standard. They argue the Crown is arguing that denunciation and deterrence must be the paramount considerations. So that has to be what we're worried about here, and less so on rehabilitation and, those kinds of, sort of positive elements there, because essentially these are offenses that are, they're always committed by people with good rehabilitative prospects. But the point is to denounce these in terms of the social to basically say, as a society, we don't put up with this, and also general deterrence so that other police officers can see this and, and listen. And quite frankly, if police officers are not sort of affected by general deterrence, then no one will be. Police officers are really your ideal candidates because they're people who are aware of the justice system. They're, uh, they follow along with it. They, and also, they're people who are making decisions at sort of the best possible, times and places, in the sense that they have access to legal counsel. Sometimes those decisions must be made on the fly and in a hurry, but they're the same kinds of decisions that civilians might have to make on the fly and in a hurry. A police officer deciding when to defend themselves and use force, civilians sometimes have to do the same things. So, and they're also, rarely are we seeing police officers acting out of addiction or, desperate hunger or anything like that might drive somebody to commit an offense, notwithstanding sort of the scariness of the punishment. So if general deterrence doesn't work for police officers, then it doesn't work for anybody, and we should abandon it entirely. So that's just kind of thoughts there. And they note here, there are cases where they talk about, the personal characteristics are positive and must be viewed as significant mitigating factors. And the Crown here also says, listen, no. They say none of these are mitigating factors apart from the absence of a criminal record, because they're things that you expect of every single police officer. Every police officer, when we're sentencing them, is always going to come as somebody who's had this, history of working as a police officer, which is often offered as mitigating. They say, listen, this person's been a police officer for however many years, and, and that's taken as deducting from the sentence, notwithstanding the fact that the court says, hey, listen, officers should be sentenced more highly. So the Crown says, no, you can't be relying on that. They note that sentences for police officer offenders should be higher than those of civilians and not lower. And quite frankly, we see that the opposite way. They also note, they say, sadly, to many members of Canadian society, the police represent a collective harm inflicted on the vulnerable and operate as a reminder of a sanctioned power imbalance over them. Public confidence is crucial. So if you're poor and hungry, it's the police that are keeping you from, sometimes sleeping in a warm place. They might be moving you along. And there's various reasons why they do that, in the sense of you might be in a spot where you are a danger or a nuisance or whatever else. But we still need to, those people still need to have confidence that the police are going to be fair to them and not, not violent to them. So they also note here, they say many sentencing cases cite this passage of saying that it's not a deliberate leap into criminality, but they note that police officers are often in the belief that they're discharging a duty. So that shouldn't be giving them a pass, because this essentially creates a second tier. What the Crown is talking about a lot here is basically saying that police officers, because of all these factors, essentially enjoy a different sentencing regime than the average person. They say collateral consequences. They note that being fired is a collateral consequence that often happens to police officers. So what a collateral consequence means is, when you get punished in some fashion, but you also suffer losses outside of that, just because of, the impact that it might have had. So public shame has been taken as a collateral consequence. Loss of privilege to own firearms. And we'll, again, come back to that one. Loss of community support. However, these are things that flow directly from the offender's conduct. And the court noted in the case of Souter, they said, collateral consequences must not flow naturally from the conviction, sentence, or commission of the offense. In fact, where the consequences are so naturally linked to the nature of the offense as to almost be inevitable, its role as a mitigating factor is greatly diminished. So let's consider an example here. Let's say you've got somebody who's been a school teacher for 15 years. and then they're convicted of some sort of offense towards children, and now they can't be a school teacher anymore. The court is not likely to say, oh, well, we're going to go easy on you because of this additional consequence of you not being able to be a school teacher anymore. It's just like, no kidding. That's what happens when, you're in that position of trust and then you violate that trust. So the Crown's position here is they say the collateral consequences of police officer offenders should be given very little weight by the sentencing court. And they point out that there are other professions that in fact face exactly that kind of rule, which include doctors, lawyers, government officials, and so forth. In particular, the courts, in many cases involving lawyers, tend to take a special delight in ramping the sentences up. It's a very different approach than what we see from police officers. I just try to avoid the criminal justice system, but, you never know is, I guess, the thing. The opportunity to make it right, which is partially because of fines and so forth, they note that also is connected to policing in the sense that the officer being able to pay $10,000 is connected to having a good job, to his former employment as a police officer. The court, in the case of Zora, which I've covered in some length in another video, says that access to justice should not depend on the ability to put forth a monetary promise. And they attempt to extend that to sentencing. I think that's going to be real interesting to see what the court says. So they say the idea that a jail sentence ought to be reduced because of your ability to pay a fine would be reprehensible to any right-thinking member of the community. And quite frankly, I agree. I think that it's very difficult to say that you should be able to buy your way out of a sentence, to buy your way out of jail time. Now, there, in terms of this, the notion that, part of their argument is also that we should essentially weigh down or weigh less strongly your past good behavior in the case of police officers. And you might think, whoa, where do they ever do that? Is that, that doesn't seem fair. But there are actually places where the courts have essentially said, listen, your past good behavior isn't all that mitigating. And one of them, for instance, is with respect to financial frauds. Because let's say you are a bank manager, and in the course of being a bank manager, you embezzle $1 million. Because some of these embezzlement files end up with huge dollar amounts attached to them. Well, you'd come in and you'd say, listen, I've never done anything like this before. This is not something that is like me. And the courts say, well, yeah, no kidding. Because if it was something that was like you, you'd never have been put as a bank manager. Your past good behavior is what, in fact, enables you to commit the offense. So that's part of the Crown's argument here, and it'll be really interesting to see what the court deals with, how the court deals with it. Now, I'm not going to go through in as much detail the defense response to this, because the defense has also filed a response to this leave application. But essentially what the defense says is, listen, the trial judge got it wrong. You're right. And, since then, what's happened is that we've actually had that adjusted by the Court of Appeal. Court of Appeal fixed the problem. Court of Appeal has denounced his conduct and has issued deterrence. And they say, listen, you raise all of these issues about power dynamics and, Black Lives Matter protests and racism and so forth. But they're not at play in this case. That's for some other case. And it's not a bad argument. Essentially what they're trying to say here is, listen, this is the wrong case. You can totally argue all of those things, but wouldn't it be better in terms of the societal argument about, say, police officer racism causing violence to somebody, that we hear this argument in that context? The problem with the defense argument, in my view, is that while this might be of heightened interest to marginalized Canadians, it's also important to all Canadians. If I get pulled over and some officer happens to recognize me and doesn't like some of the things I've said and decides he's going to punch my teeth out, I would like to know that that officer could be held accountable. People who protest would like to know that, the officers could be held accountable if they use excessive force in breaking up that protest. All sorts of people may have police interaction, not just the sort of people that the defense identifies as really you should save this for one of them. Because, of course, if the court does that, then that's of tremendous benefit to their client. If the Supreme Court decides to hear it, it's unlikely that they're going to move the sentence down, and I think it would be quite likely that the Supreme Court's sort of statement on this would be to move the sentence up. If I was a betting man, I would say that I think the Supreme Court might hear this one. I think it's a real possibility. This is a major issue that keeps coming up in terms of the news, and it doesn't seem to be one that the Supreme Court has really weighed in on before. So it'll be really interesting to see what the Supreme Court does. Now, I did mention as well that I wanted to cover something that I didn't think anybody else had spotted that is a problem, that is an error at the trial court level that if I was the Crown, would have made some noise about. And that is right here. So they say, the Crown also sought a Section 109 weapons prohibition. I do believe it is available, but I would not impose it or the discretionary DNA order in any event. They are not warranted on the facts. Now, this is a very weird sentence to me because 109 weapons prohibition is kind of a specific section of the criminal code. And it's not really, well, we'll just go and have a look at section 109 here. Mandatory prohibition order. Mandatory. So where this happens, where any of these things are triggered, the court that sentences the person or directs that the person be discharged, as the case may be, shall, which is must, in addition to any other punishment that may be imposed. So make an order prohibiting the person from possessing any firearm, crossbow, prohibited weapon, restricted weapon, prohibited device, ammunition, prohibited ammunition, and explosive substance during the period specified in the order. And so for a first offense, it'd be any firearm other than a prohibited firearm or restricted firearm, and any crossbow, restricted weapon, ammunition, and explosive substance for at least 10 years. And for any prohibited firearm, restricted firearm, prohibited weapon, prohibited device, and prohibited ammunition, the period is life. So, and that's the minimum on the first offense, life. Now, in terms of this, one of the things I thought is maybe the judge got it wrong and didn't mean to say 109, meant to say 110, because 110 is a discretionary prohibition order, which means that the judge may and shall consider whether or not that they should impose it, but they don't have to. It's where the court decides that it is so desirable, the court shall order it, but it's optional. So that's the discrepancy there. And so some offenses trigger a mandatory order, some trigger a discretionary order. However, when we look at the criteria for the mandatory order, an indictable offense, and the Crown did proceed by indictment on this one, in the commission of which violence against a person was used, threatened, or attempted, and for which the person may be sentenced to imprisonment for 10 years or more. So we got to ask ourselves, what is the maximum sentence for criminal negligence causing bodily harm? And we see here, causing bodily harm by criminal negligence. Term of not more than 10 years. So we've got our 10 years. So if you find that this is by violence, that violence against a person was used, threatened, or attempted, then that takes you into the mandatory term. So the language here is a little weird, as I said, because it seems like the judge is kind of behaving a little strangely. It says here that the judge indicates, I do believe it is available. If it's available with a mandatory order, then it has to be imposed. Or, I mean, the other way around this, the way if we're being very generous in terms of the trial judge, is the trial judge possibly saying, listen, I don't think that this was violence being used, but I don't think that that's reconcilable with the decision itself, because the decision itself finds that this vehicle was being used intentionally to ram them. And I mean, that seems like violence to me. And so once you get there, you have to say, listen, that triggers it. It triggers a mandatory firearm prohibition. And the Court of Appeal doesn't seem to address this further order to say, listen, a firearm prohibition has to be imposed. So I wonder if the Crown didn't argue that point or if something else happened. But I mean, certainly if I was the Crown, I would have been arguing this to say, listen, this isn't optional. This isn't discretionary. The judge has no option. And certainly a civilian in this situation, they would have issued a firearm prohibition. This wouldn't have been in question. So I think the Crown could have certainly made some noise here to say, listen, this is part of the package of not properly weighing this and of treating the police officer different than the court would have treated an ordinary civilian in these same shoes. So this is a substantial legal error, I think, in the sense that it's a clear error. I don't see how you can get around this mistake. And I think it's one that very much, is in something that the Crown could have argued. I think, so I don't know, maybe I'll end up helping the Crown out on this one, but I kind of think it's too late for them to make this argument unless this accused is resentenced, because that's what the Crown is asking for, is they want a resentencing with some guidelines and some direction from the Supreme Court. And so maybe he'll be treated like, Joe Average gun owner who certainly would have faced that prohibition here. Anyway, thank you for watching. I just wanted to really dive into this case because I think it's going to be fascinating. This is a real opportunity for the Supreme Court to tackle this in a substantial way and to really give some direction to the courts, because this is something that is becoming a bigger and bigger social issue. And quite frankly, I think if they pass on this opportunity, that they're going to regret it, and they're going to end up having to come back to this later with some other case. And so we'll see. I guess that's about it here. If you've enjoyed this video, please like this video, share it with your friends, subscribe to see more content. It takes a fair bit of work to produce something like this, because I had to read several cases and get a hold of materials that are, big, long challenges and so forth. But this one took me way longer than I wanted it to. So, yeah, like, share, subscribe to see more content. I also want to thank my Patreon supporters. You guys really do help keep this channel going. So at the $50 level, Jonathan Wheeler, Canada's National Firearms Association, Mike, Kyle Martin, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Peter Hilger, Mark Whittington, Jane Babin Luxer, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Del Salt. Thank you as well to everybody at the $10 level who will be in the crawl immediately following. Thank you for watching, and let me know what you think. I mean, maybe I'm out to lunch here. Maybe you're thinking, hey, this officer, that was the appropriate sentence. I will admit, from the news articles about this, and I did read several news articles, not just the CBC article, but a bunch of others, I think that they really downplayed a little bit just how the officer is fairly sympathetic outside of this day. Like, outside of this moment, he's a person who does a lot of volunteer hours. And, I gave a bit of a cynical reason for him getting the volunteer hours in. But from what has been reported in terms of like the decision, in terms of, his commitment to volunteer hours, I suspect what it was is, my hunch is just that he kept going and doing what he does normally and just tracked his hours. And that's just where it landed. Because most people who are sentenced to community service hours, they don't do extra. They, if you're sentenced to 50 hours, people do 50 hours on the dot and, tools down, walk out the instant they hit, 5-0. Like an extra 40 hours is not nothing. That's a substantial chunk of time. And that really happens only when somebody kind of, likes doing it. I have seen it before where somebody, is directed, hey, you got to volunteer, and they just decide they've taken a liking to it, that they keep doing it and it becomes a regular thing for them. And I actually had one person who, they indicated after they were sentenced to community service hours that they thought that was the best part of their sentence because they were like, I love doing this, and never would have started. But he was already doing all this community service work. So it's really tough to say. I mean, I think that even like from what it seems like, even amongst police officers, this guy seems to be a fairly, stand up guy outside of this one horrible screw up that ultimately caused this woman, permanent injuries. It's sentencing's not easy. And as much as I will, as much as I pointed to an error in the trial judge's decision, and I think the sentencing itself was in error, and certainly the Court of Appeal agrees with that, it's still tough. I still think that, judges have a really hard job here. So, yeah, I'm always torn with these kinds of things, but that's one of the things the Crown is saying is, hey, listen, lots of these are situations where judges are torn. I think they actually use that language. You should give them direction as to which way they need to land when they're torn like that. So anyway, as I said, really potentially important decision. And I'm hoping, and I think they will, but I'm hoping that the Supreme Court takes it up. I really want to see what's going on here. I also, at some point in the near future, need to get a video out on these things, the Omega internal gun lock. I was going to do that first because I really owe somebody the video. I ran into a little bit of a production hiccup on that, so it's stalled a little bit longer, but I'm going to try to get it sorted out as soon as I can. Anyway, thank you once again for watching, and I hope this is armed you with knowledge.